All right. Everyone is appearing via the Zoom teleconference platform, including Ms. Holmes, who is in Union City. Is that right? Okay. The matter is on today for bond reduction. I would like to say that the court has put this case on its YouTube live stream in order to, its YouTube live stream channel in order to ensure that the public remains having access to its business. And at this point, I'd like to, is Ms. McClure, is this you?
Judge, can you record, please?
All right, damn, there's a lot of things to do here. Okay. And Ms. McClure, is this you?
Yes, Your Honor.
Okay, I'll turn this matter over at this point to our Assistant District Attorney, Ms. Lindsay McClure, to see if there are any questions that she would like to pursue regarding the defendant's presence here today.
Thank you, Your Honor. Good afternoon, Ms. Raz.
Good afternoon.
Have you had a chance to discuss this bond hearing with your client, Ms. Holmes?
Yes.
And does she understand that she has the right to be physically present for this bond hearing?
She does.
And do you mind if I ask Ms. Holmes a question?
Yes, of course. I mean, no, I don't mind.
Ms. Holmes, can you hear me?
Yes.
Do you understand that you have the right to be physically present for this bond hearing?
Yes, ma'am.
Do you waive your right to be physically present for this bond hearing and wish to proceed via Zoom?
Yes, ma'am.
This state is satisfied, Your Honor.
All right, Ms. Raz?
Thank you, Judge. Your Honor, Ms. Holmes would like to thank the court for hearing bond in her case today. Judge, she has been in jail since April the 15th. So April, May, June, July, August, September, October, November, December, January. That's over 9 months now and 280 days. Your Honor, her last bond hearing was on September the 16th of 2020. The court granted her a $20,000 good bond at that point. So, Your Honor, during that hearing, the court found that Ms. Holmes met the Ayala factors and granted a bond. Of course, the primary purpose of setting bond is to ensure that Ms. Holmes comes back to court, not that she stays in jail. And Your Honor, she can't make a $20,000 good bond. So we are asking that that be converted to a signature bond through pretrial services, and that the requirement that she have an ankle monitor, which is a condition of the $20,000 bond currently, be removed. Your Honor, I would like to point out Levita Woodard, who has joined us by Zoom today. Ms. Woodard, will you just say hello to us?
Yes, hey, how y'all doing?
Thank you for joining us.
No problem.
And is Kenneth Ellis also here? Mr. Ellis may not have made it yet, but Your Honor, Levita Woodard is Ms. Holmes' first cousin. I talked with Ms. Woodard, and Ms. Woodard says that she described their relationship like sisters. They grew up together. And Ms. Holmes would live with Ms. Woodard if she was released on bond. She has lived with Ms. Woodard before with a problem. Your Honor, Ms. Woodard lives at 205 Flat Shoals Road, apartment C2. She lives there with her 7-year-old daughter, and those are the only 2 people in the home. And as you can see, Your Honor, she works at McDonald's. She's been there for 2 years now. And
Welcome to Zoom. Enter your meeting ID followed by pound.
Hey, just give me 1 second. Okay. I'm sorry, go ahead, Ms. Raz. Is the 2-year-old daughter Ms. Woodard's daughter or the defendant's daughter?
7-year-old daughter, and that is Ms. Woodard's daughter.
Okay, sorry.
Ms. Holmes does have children of her own. Your Honor, she has 4 children. Her oldest daughter is Armani. Armani is 9 years old. Her second oldest is her son, Winston. Her third youngest is her daughter, Kamaya, and the fourth is her son, Xavier, who is 1 year old. At this time, Your Honor, Armani is staying with her dad as well as Miss Holmes' mother. She's back and forth. Winston is with Miss Holmes' mother. Kamaya is with Miss Holmes' cousin, Jasmine Sims, and Xavier is with Miss Holmes' cousin, Tempest Sims. So, Your Honor, the children are being cared for, but I mentioned that to show Miss Holmes' vested interest in remaining in our community and caring for her children. She does plan to resume custody with her children, or to resume having custody of her children once she is released. She is Atlanta born and raised, Your Honor. She celebrated her 26th birthday this past January the 9th, I believe. Did I get that right?
7.
7th.
7th. I'm sorry. Thank you. And Your Honor, before her arrest, she was working as a hairstylist. I understand that Miss Woodard has spoken with the manager at McDonald's and that Miss Holmes plans to seek employment at the same McDonald's where Miss Woodard works upon her release. Your Honor, I'll speak to the case just a little bit. I will first say that, 280 days into Miss Holmes' arrest, it is, I don't have any evidence that the state is going to be able to show that Miss Holmes was actually involved in this robbery at all. I have gotten the body camera. The officers respond to James Moore, who says that he was robbed by a man, gives a brief physical description of the man. In his 911 call, he describes a woman, but he says in his 911 call, "I'm not trying to get the female involved. She's just with a dumb person." I'm paraphrasing there. But he makes it clear in his 911 call that this second person, this woman, isn't really, he's not trying to get her involved. I'll leave it at that, Your Honor. Nevertheless, regardless of that woman's involvement, I don't know how they connect Miss Holmes to the identity of that woman. The complaining witness, Mr. Moore, again gives a very brief description. The only physical description he gives is to say that she's light-skinned. And Your Honor, I think there are plenty of women out there who might fit that description. He also gives a description of her clothing, saying that bear with me one moment, Judge. I'm sorry. That she's wearing a medical mask, what he describes as natural jeans, which he later goes on to explain just means regular old blue jeans, no holes, or tears or anything distinctive. A light colored shirt or jacket, possibly white. Your Honor, there is, sorry? Okay. Your Honor, at the time of Miss Holmes' arrest, which is, I believe, about 15 hours later, the officers respond at about 4:50 a.m. Miss Holmes is arrested later that night at about 11 p.m. And at the time of her arrest, Miss Holmes is wearing a black jacket over a gray hoodie, over a hot pink shirt, on top of light gray leggings. So absolutely no relation to the clothing description given by Mr. Moore. As far as I can tell, there is no interview with Ms. Holmes. She does not admit to being involved in this robbery. As far as I can tell, there is no follow-up with Mr. James Moore. There is no effort to bring him to the scene of Ms. Holmes' arrest to identify her. There's no effort to show him a photo lineup with Ms. Holmes' picture in it so that he can point her out and say, yeah, that's the woman who was with the guy who robbed me. I don't believe Mr. Westbrook gives a statement, and I don't believe Ms. Holmes gives a statement. So, Your Honor, I think Ms. Holmes' connection to this robbery is tenuous at best. Of course, she is arrested, again, about 15 hours later, pumping gas into the car that was reported stolen. And Your Honor, I believe the evidence will show that Ms. Holmes Ms. Holmes was driving that car because she needed transportation to one of the fathers of her children. She needed to get money from him. And so she accepted the transportation that was offered by Mr. Westbrook. Your Honor, I think this is the evidence that I'm seeing does not point to a robbery. I think it's a tenuous theft by receiving at best. Nevertheless, Your Honor, I don't think I need to argue the Ayala factors. I think a court has already decided that Ms. Holmes meets them. And Your Honor, she can't make bond. She's been in jail for 10, 11, 12, 4 months since the $20,000 bond was set. She's indigent. A $20,000 bond is not necessary to ensure that she returns to court. I believe that having her report to pretrial will be. And of course, if she doesn't report to pretrial as we tell her to, then there will be a warrant for her arrest anyway. But Your Honor, I believe she's demonstrated, and I believe her support network has demonstrated that she's a good candidate for bond and that she's got a plan for getting back on track, for becoming gainfully employed, for re-engaging with her children, taking custody of her children, and to return to court when she's called upon to do so.
Now, let me explore that a little further, Ms. Raz. Does she anticipate having these 4 or some combination of children moving in here with Ms. Woodard?
Your Honor, I believe that's part of the discussion. I don't anticipate that it would happen all at once. I believe that her priority is to regain custody of her 2 youngest, Xavier and Kamaya. It sounds like the oldest, Armani, has a father who is engaged and in the picture. And Armani can stay with Dad in the meantime. And as for Winston, I know he's with Miss Holmes' mother. I think that eventually, and if Miss Woodard, after conversation with Miss Holmes, was agreeable to have Winston in the home, that might be a possibility.
So Kamaya and Xavier, I don't want to, I'm just asking the question. This is just exploring the situation, because I don't want you to come right back and say that Kamaya and Xavier, that was complicated trying to live with Ms. Woodard and her daughter. Is that anticipated as part of this or not?
I haven't spoken with Miss Woodard directly about it. If we'd like to have her speak on it, I'm sure she would be willing. When I talked to Miss Holmes, I did get the impression that yes, that was anticipated.
Well, Ms. Woodard's right there.
Yes, it's more than welcome. She's more than welcome, her and her children. They can stay there. I make sure she stay on track.
Okay.
Thank you.
Anything further, Ms. Raz, before we hear from the state?
No, Your Honor. Thank you.
Okay, Ms. McClure?
Yes, Your Honor, thank you. Your Honor, the state would oppose a signature bond in this case, and the state would actually also oppose a bond reduction, Your Honor. the state feels that the bond currently set, given the serious nature of the charges, are reasonable. And based on the fact that on probation from Cobb County, Your Honor, from a 2018 case for theft by taking. And Your Honor, the state does have a record of a failure to appear by Ms. Holmes out of 2019 for Cobb County. So based on those factors, Your Honor, and based on the serious nature of the charges, the state would argue that the bond currently set is reasonable.
And did you say that was 2015?
It's a 2018 case out of Cobb County, Your Honor. She's on probation for that, and she has a failure to appear out of Cobb County from 5/17/2019.
Okay. Ms. Raz? And let me tell you one thing. Let me tell
Huh? Yeah.
hang on. Let me tell Ms. Holmes and let me tell everyone involved in the case. When I left the office last week, I was not aware that we wouldn't be allowed back in the office until Thursday. So I don't have my notes on this case, so I'm probably not going to be able to give you an answer right this minute, but I will do so as quickly as I can. Okay, Ms. Raz?
Your Honor, yes, I was aware that Ms. Holmes was on probation for a 2018 case from Cobb County. I believe it is for one count of theft by taking and one count of theft by receiving. I would emphasize that I don't think one felony conviction bars you from being a good candidate for bond under the Ayala factors. I would emphasize that that is a non-violent conviction. And Your Honor, I did speak with Ms. Holmes about the failure to appear. It is my understanding that she did receive notice of her court date. She called Cobb County to ask for it to be rescheduled, saying that she did not have arrangements for childcare and that she did not have enough money to pay for bus fare for her and her 4 children. And it's my understanding that that Cobb County told her that they were not able to reschedule it. So in an effort to deal with the inevitable failure to appear warrant, she began making arrangements for her children to go and live with the people with whom they are now living. So she knew about that court date. She took steps to rearrange it. She's not running. She's not willfully failing to appear. She had logistical challenges, and she understands the consequences for those.
Okay, and does she have a hold out of Cobb?
No, Your Honor.
Okay, and my notes will reveal this, but didn't I know this before?
No, Your Honor, I don't think you have any notes on Ms. Holmes. This is the first time Your Honor has heard her case. You did hear bond for Mr. Westbrook previously, and I understand that the court reset Mr. Westbrook to today to make a decision on his bond hearing.
Who granted the $20,000 bond?
That was a non-complex judge prior to indictment, Your Honor.
Okay, I got you. All right, so I didn't know about the failure to appear, and I didn't know about the Cobb County probation matter. And so I'm hearing this for the first time. I'm sorry, that's exactly what my notes would have told me, and I apologize. Or lack of notes. Okay, I'll get something now. If there's nothing further, Ms. Holmes, I appreciate your appearing today, and I'll get something out as soon as possible. And I'm sorry, deeply sorry about the circumstances that have us a bit discombobulated right now, but I very much appreciate the argument of your attorney, and I appreciate the response of the state.
Is Your Honor, are you able to articulate an oral ruling on our motion or not at this time?
No, I'm not able to do that right this moment, but I will let you know.
Thank you, Your Honor.
Okay, thank you. Thank you, Ms. Holmes.
And Your Honor, before Ms. Holmes leaves, do you anticipate when she can expect a ruling?
Before the end of the week.
Thank you, Your Honor.
Did you hear that, Kathy? Okay.
I'll make sure she hears.
Yeah,
Yes, I heard it.
from one of you. I've got two. I've got the two best advocates there could possibly be. Okay. Who do we have in courtroom number 2?
I believe my client, Mr. Westbrook.
Oh, it's okay. All right.
Judge, can I have a second to talk to him very
Yeah.
briefly?
And unfortunately, I'm going to have to be the one to do that. So let's go through our procedure here. Okay, breakout room.
Hold on, Judge. Miss Hawkins.
Yes, ma'am.
Call. I'm gonna give you the number to call here. That way we continue the calendar moving on.
It won't take that long.
That's what you say.
That's what I know.
We have talk back from the jail. That is great. They have said what we've all wanted to say for years.
I am ready when you are, though.
Okay, Judge, you can go ahead and put them in the
Wow. Okay. Whoa, wait. Okay. All right. I'm gonna do open all rooms. Did everybody just get an invitation? Okay. That was amazing. Oh, but I didn't just close it. Did I just close it accidentally? Ms. Raz, were you in breakout room?
I was, Your Honor.
Did I accidentally close it?
Not before I left.
Did they kick you out? They kicked you
No.
out, didn't they?
No,
Yeah, they did. Yeah,
I
they
left.
kicked you out.
Oh, they did?
No, Ms.
Your Honor,
McClure, did you have lunch?
I don't think we need to reopen the record because I did state that the police response was just before 5 a.m. and then they were arrested at 11 p.m. So I don't think we need, I stated that on the record, but I also stated that
You said 15 hours later.
it's not. That I did the math. It's like 18 hours.
We can do whatever you want to do. I don't know that I actually heard the time, but if you want to reopen, we can. I mean, if you would feel better.
Could we quickly, while we're waiting for Miss Hawkins?
Okay, Ms. McClure, do you have you with us?
Here.
Okay. Samantha, you with us?
Yes, I am.
Okay, Samantha, could we reopen the Antoinette Holmes record for just a moment? You
Yes.
ready? Okay. On the state of Georgia versus Antoinette Holmes, 20 SC 176974, Ms. Raz wanted to clarify one point. Go ahead, Ms. Raz.
Thank you, Judge. I apologize for the miscalculation. In my first argument, I told the court that police responded at about 5 a.m. on April the 14th of 2020. I believe, in fact, body camera starts at about 4:50 a.m. I see from the CAD log that I subpoenaed that the initial call was actually closer to 3:39 a.m. on April the 14th. And Mr. Westbrook and Miss Holmes are arrested at approximately 11 p.m. On the same date, April the 14th. So from the time of the 911 call, which is about 3:30 a.m., 4:35, 36, 37, 38, 39, 30, 10:30, that is about 19 and a half hours, not 15. So from 911 call to arrest is about 19 and a half hours. from officer's initial response to arrest is about 18 hours, not 15 as I previously stated.
Okay, would the state like to add anything?
No, Your Honor.
Okay, and I would just like to note that Ms. Holmes was not present for that clarification, and that's, you understand that, correct, Ms. Raz?
Yes, Your Honor.
Nevertheless, you wanted to make that clarification.
I did. Thank you, Judge.
Okay, thank you. We'll close that record down. Again, thank you. Okay, now do I have, we back for Mr. Westbrook?
Yes, Judge.
Okay, all right. This is the state of Georgia versus Quintavious Westbrook. And Samantha, we're starting this one. And this is 20 SC 176974. Today is January the 19th, 2021. Everyone on this call is appearing via the Zoom teleconference platform, including Mr. Westbrook, who is at the Fulton County Jail, but appearing via Zoom. I'm going to let the prosecution start in just a moment, asking any questions they may want to ask with regard to Mr. Westbrook's appearance here today. I would just like to say that we have this matter on for bond reduction, and we are transmitting these proceedings via the court's YouTube live stream channel, ensuring that the public's business remains open and accessible to it. And again, as I said, I'm going to turn this over to Ms. Lindsay McClure. Ms. Janie Hawkins represents Mr. Westbrook. Ms. McClure?
Thank you, Judge. Ms. Hawkins, have you had a chance to discuss this bond hearing with your client, Mr. Westbrook?
Yes, ma'am.
And do you mind if I now ask him a couple of questions?
I do not mind.
Mr. Westbrook, can you hear me?
Yes. Yes, ma'am.
Do you understand that you have the right to be physically present for this bond hearing?
Hey, Judge, can you mute
Courtroom?
that cell phone is?
Yeah.
Please.
Got it.
Westbrook, do you understand that you have the right to be physically present in the courtroom for this bond hearing?
Yes, ma'am.
And do you waive that right to be physically present and wish to proceed via Zoom?
Yes, ma'am.
Okay. The state is satisfied, Your Honor.
All right, Ms. Hawkins?
Yes, Judge. And this is the case that you actually did take notes. So I understand that Your Honor doesn't have her previous notes. So you have heard my bond argument in this case, but I'll go through it again, Your Honor.
Okay.
So Mr. Westbrook is 18 years old. His birthday is February 24th, 2002. So my understanding, Your Honor, is that previous to the indictment in this case, which came down, I think, sometime early or mid-December, Mr. Westbrook was only charged with hijacking a motor vehicle and aggravated assault. A judge, a non-complex judge, heard the bond on the hijacking the motor vehicle and the aggravated assault, granted him a $15,000 bond in those two charges. I believe when the case was indicted, an armed robbery and a possession of a firearm was then added. So he is in a no bond status on those two charges. So I am looking to get his bond in the two charges of hijacking and aggravated assault reduced, and then giving him a bond in the armed robbery and the possession of a firearm during the commission of a felony. Mr. Westbrook, like I said, is 18 years old. He has no criminal history, no prior interactions with the law. Your Honor, he was not actually working when he was arrested. However, he had a job interview at Chinese cafeteria that he did not get to make due to his arrest. And he was arrested like his co-defendant, Ms. Holmes, on April 15th, 2020. So he too has been in custody for well over 250 days, Your Honor. He is one of 9 siblings. He's the 7th child. His mother is still living. However, his father has passed away, Your Honor. Based on the information that I provide, I'm sorry, he's also from Atlanta. He completed the 10th grade at Carver High School. But as I explained to Your Honor last time we were before you on this matter, my understanding is that there were 5 people involved in this incident. This incident included some neighborhood people, and most of the individuals involved are juveniles, which is why they're not listed on the indictment. And those are the individuals who we believe actually committed this armed robbery. My understanding is that there was an altercation between one of the juvenile individuals, between his mother, and the alleged victim is the mother's boyfriend. So this juvenile individual was upset about how the alleged victim was treating his mother, and he wanted to retaliate. So Westbrook was not a part of that retaliation. He was not a part of that armed robbery. He merely lives, I guess, in the neighborhood, or he was just around the neighborhood. Your Honor, as stated by co-defendants counsel, I believe at best the state would be able to prove maybe possession or theft by receiving stolen property, because I do believe that Mr. Westbrook was arrested in the alleged hijacked vehicle. Unlike the co-defendant, I do not have any discovery. I don't have any body cam. I've never heard the 911 call. So I cannot attest to, and I can't speak to, that discovery, Your Honor. My understanding is there was not a photo lineup done. If there was a photo lineup done, my understanding is that this alleged victim would not be able to pick out Mr. Westbrook. He was not a participant in the armed robbery. And there was no statement made by Mr. Westbrook that incriminates him, places him on the scene, or anything of that nature. Your Honor, he obviously met the Ayala factors for the first 2 charges for which he was charged with pre-indictment. And Your Honor, I submit to you that he still continuously meets those Ayala factors. He has no criminal history. He has ties to the community. He does not know who this alleged victim is. He does not have a relationship with him. He's never really, I think he said to me that he's seen him maybe one time, but he has no idea who this man is. So he's at no risk of intimidating witnesses. So Your Honor, I ask that you grant him a signature bond through pretrial services. He's 18 years old. He doesn't have a job. He has no means of paying for a bond. You can put him at the highest level. His mother obviously has other children that she has to care for. And he would be staying with his aunt. And he has confirmed that he has spoken with her. I've reached out to her. I was unable to make contact with her, but he has confirmed that he would be staying at 450 Thomasville Boulevard, apartment 155, and that's Atlanta, Georgia, 30315.
Isn't that part of in the Thomasville neighborhood involved in the underlying incident?
I don't have discovery, Judge, so I couldn't tell you.
And did you say 450 Thomasville Boulevard?
Yes, Judge.
Okay, and have the so-called juveniles involved in the case been charged?
Not to my knowledge.
Okay, and do you know the name of the aunt?
Felicia Holmes.
When did I hear this?
2 weeks ago, maybe.
And did I deny bond?
No, you wanted to lay eyes on Mr. Westbrook.
Sorry. Okay, because the Felicia Holmes was, and was she the, how was she involved?
That's his aunt. Ms. Holmes is a co-defendant.
Yeah, okay, but so are they cousins?
They are.
Okay. Would they be living in the same place?
No.
Okay. Okay, yeah, I'm sorry.
It's okay, Judge.
Don't make fun of me.
I'm not. I would
okay.
never.
Yeah, well, it's good. Okay. All right, I may have more questions, but I apologize for that. Okay,
No problem.
thank you. Ms. McClure?
Thanks, Judge. I'll be brief since you've already heard the state's arguments as well, and I'll just summarize. Your Honor, the state would oppose a bond reduction in this case on the hijacking charge and the aggravated assault charge, Your Honor, and the state would ask for no bond on the armed robbery charge, Your Honor. These are very, very serious charges, Your Honor, and the state would argue that the defendant is a danger to the community. He is alleged to have robbed the victim at gunpoint in this case, Your Honor. So as a result, we would ask that you we would also oppose a signature bond, Your Honor. So we would ask that you keep the bond the same on those two charges because we feel it's reasonable given the serious nature of the charges. And we would ask that you deny bond on the armed robbery charge, Your Honor.
Okay, and again, forgive me for one thing, because I also do not have access to Odyssey right now. Was the $15,000 bond, who granted that? I know that was on two charges, but who granted that? Was it a magistrate?
Hold on.
It
Yeah,
was, yeah.
Okay, great.
And Judge, if I could just briefly respond.
Yeah. Wait a minute. Let me make sure, Ms. McClure, are you through?
Yes, Your Honor.
Okay, go ahead.
Yes, Judge. So we understand that this is a serious charge, and as the state indicated, it is an allegation. So these are just, for a lack of a better word, an allegation. I don't have any discovery. I don't have anything that demonstrates whether or not the state can meet its burden of proving beyond a reasonable doubt. However, this is not trial. This is the stage of determining whether, if released on bond, Mr. Westbrook will return to court. And I believe that he hasn't given, Your Honor, any reason that he would not return to court.
Now, Ms. Hawkins, who's older, Ms. Holmes or Mr. Westbrook?
Ms. Holmes.
She's 26?
Yes.
And he's 18?
Yes.
Okay. And so they were just they were arrested when sometime later in the car.
Yes, that is my understanding.
Okay. And then there's your argument is that this was just the boyfriend's pointing the finger at everybody. Mad.
I don't know who the alleged victim pointed a finger at because I don't have discovery, but I believe the reason why Mr. Westbrook is tied to this case in the first place is because he was arrested in the vehicle. Yeah. The victim is alleging that he was robbed at gunpoint. So just because that allegation is made and Mr. Westbrook is found in the vehicle that is allegedly to have been taken, then I want to say that the leap has been made that Mr. Westbrook is the individual who actually hijacked the vehicle. However, I can't assess that information because I don't know what the victim said. I don't have any of that information. I just can tell you based on the information that I have that Mr. Westbrook is not the hijacker.
Okay. And so if he lives with Ms. Holmes, Ms. Holmes is going to be living somewhere else.
That is correct, Your Honor.
Who all is in Ms. Holmes' household?
Based on what I heard during co-defendant's argument, I believe one of her children, one of Ms. Holmes's children will be present in the home.
And then what about job prospects? So he was being interviewed by Chinese Kitchen or something.
Cafeteria.
Chinese cafeteria. And so he wants to work.
Yes.
All right. Okay. And again, my statement remains, and I am glad I had an opportunity to see him. I'll go back to those notes and I'll get something out by the end of the week.
Not a problem, Your Honor. Thank you.
Okay. All right. Thank you, Mr. Westbrook. Okay, thank you. Thanks, Ms. Hawkins.
Thank you, Judge. And I believe that concludes my business today. May I be excused?
Sure. Now, I have a track record of excusing you and needing you later, but I'm going to take your word for it.
Well, Judge, you have my cell phone number and you can reach me at any time, any hour, any day.
Okay, I love it. And I think you have my cell phone number.
I do.
Good.
Who is this, Mr.?
Thank you. You're excused.
Thank you.
Kathy. Who've we got?
Judge, we have positions 1 and 2.
Oh, okay.
Okay.
Okay. All right, Mr. Cox. Okay. Whoops. All right. We ready to get started? Hey, Mr. Cox.
I'm ready, Your Honor.
All right.
And Your Honor, I would just like to quickly note that this case, these two cases will be handled most likely by our domestic violence unit.
Okay.
But I'll be handling the bond hearing.
Okay. And let me just ask before I embarrass myself further, is this an original bond hearing?
I believe, hold on. I believe it is an original bond hearing and a probation revocation.
Right. Got it. Okay. All right. You ready, Samantha?
Yes. Yes, I am.
This is the state of Georgia versus Kariga Cox. There are two cases on the calendar for today. The first is 20 SC 176834. The second one is 19 SC 172368. These matters are before the court, number one on bond. The second one I think is on for probation revocation. Today is January the 19th, 2021. Everyone appearing today is appearing via the Zoom teleconference platform, including the defendant, Mr. Cox. The court is broadcasting this matter via the court's YouTube live stream channel so that the public's business remains open and accessible to it. At this point, I'm going to turn this matter over to Ms. McClure, who is representing the state, to see if she has any questions of the defendant and his counsel regarding defendant's appearance via Zoom today. Ms. McClure?
Thank you, Your Honor. Ms. Raz, have you had a chance to discuss this bond hearing with your client, Mr. Cox?
Yes, I have.
And do you mind if I ask him a few questions?
I do not.
Mr. Cox, can you hear me? Mr. Cox, can you hear me?
We can't hear and he's not muted.
No, he's not muted. You're gonna have to speak up.
We can hear you. Okay.
You gotta speak up.
Yes, ma'am.
Did you have a chance to speak with your attorney about this bond hearing?
Yes.
And do you understand that you have the right to be physically present in the courtroom for this bond hearing?
Yes, ma'am.
Do you wish to waive the right to be physically present and wish to proceed via Zoom?
Yes, ma'am.
Okay, the state is satisfied, Your Honor.
All right, Ms. Raz. Ms. Raz, you ready?
I'm sorry, Judge. If I could have just a moment.
Sure.
I'm attempting to connect my phone, which I'm using for our office computers don't have web cameras. I've been using my phone today, and it is just informed me that it's losing power. So I'm trying to connect it to a power source and still kind of maintain a good or adequate visual. Okay, thank you for your patience. Your Honor, yes, we are here in Mr. Cox's cases, two cases, 20 SC 176834, as well as the probation revocation in 19 SC 172368. I will note for the court that there was a probation revocation hearing held in the 19 SC case. I believe it was back in September of 2020. So it appears that on September of 2020, September 23rd, a hearing was held. A transcript was filed on October 21st, 2020 of that hearing, and I'm looking at the transcript now, and my apologies, it appears that the hearing was actually held on August 31st of 2020. So Judge, on August 31st of 2020, Mr. Cox goes before Judge McBurney, and there's a probation revocation hearing. Your Honor, the probation revocation is essentially non-compliance with drug court and these new charges. Your Honor, Ms. Butler, the complaining witness in this case, is present for the hearing by Zoom and explains to the court that the allegation as charged is not correct. I will note that I've spoken with Ms. McClure, and Ms. McClure has had some trouble obtaining an incident report. It appears that this was a response from the Fulton County Sheriff's Office. The Fulton County Sheriff's Office, I believe, has indicated to Ms. McClure that they don't have an incident report for this incident. Nevertheless, Your Honor, Ms. Butler comes to court for the probation revocation and says that, yes, there was a physical altercation, but it wasn't nearly as serious as you guys are making it out to be. Me with a closed fist. Instead, he slapped me with an open palm, and that there was no blood drawn, no injuries. She didn't receive any medical attention. So, Your Honor, at that point, Judge McBurney determines that Mr. Cox has violated his probation. So we're not here today to determine whether he has violated his probation. We're here today to determine what his consequence will be for violation.
Did Judge McBurney revoke his probation?
So he basically found that Mr. Cox was in violation of his probation and withheld sentencing, for lack of a better term, or withheld revocation. At the time, Mr. Cox was hopeful that he would be reaccepted into drug court. And talking with Mr. Cox and talking with Ms. Butler, I understand that he was doing really well in drug court. Mr. Cox and Ms. Butler do have a complicated history. She is the complaining witness, and I believe 3 cases now where he has entered pleas. The most recent of which is the 19 SC, and he was sentenced to drug court for that case. Your Honor, Ms. Butler and Mr. Cox both tell me that he was doing really well in drug court. He really liked it. He enjoyed the structure. It was really helping him. And then when the pandemic hit, drug court started shutting down a lot of its in-person assistance. So he continued to participate in classes online, but online classes just weren't giving him the structure that he needed to not to relapse, Judge. So, Your Honor, it's clear to me that the root of this issue is Mr. Cox's substance abuse. And Your Honor, what I'm asking you to do today is to grant him a signature bond on the 20 SC case, allowing him to be released only to the Georgia Works program. Mr. Cox has been accepted into the Georgia Works program. Your Honor, I recently forwarded you the acceptance letter for that program, and I'm asking that his revocation be commuted to the time that he served upon entry into the Georgia Works program. Your Honor, I understand Miss Butler, and she may be on the line with us today. I didn't see her before I started my argument, but I understand that that doesn't go far enough for her. Miss Butler asked me, or at least I told Miss Butler that I would tell the court that she wants Mr. Cox home. She wants Mr. Cox home so that he can support her, so that he can support the 2-year-old son that they have together, Jakari. She wants Jakari's dad to be there for him as he's growing up. She is not afraid of Mr. Cox. She does not want him to remain in jail. She wrote the court a letter that she read during the probation revocation, intimating all that. And she also mentioned to me that she's told this to the state. This is the same information that she's given to the state. Your Honor, I do believe that Mr. Cox meets the Ayala factor.
This man's still on.
I don't know if that's
To
Butler.
Atlanta.
Hang on just a second. I don't know if this is Ms. Butler or not, but we can ask in a minute. Go ahead. I'm sorry.
Pardon me, Judge. I was saying that Mr. Cox was born in Baton Rouge, Louisiana. He moved to Atlanta in 2000. He followed his mom, his dad, and his sister here. His sister was attending Clark University at the time. He went to 11th grade. He received his GED in 2013. And today he is 40 years old. Before his arrest, Your Honor, he was working. He had been at he had been at Stryker Medical, which is located in Atlantic Station, for about 2 years. And he was also doing work for Universal Furniture, which furnishes dorms for Georgia State. He was contracted through the staffing agency People Ready.
Let me ask you, Ms. Raz, and I will ask the state as well. Does Judge McBurney have this under advisement? Because that's one thing I was a little confused about. If he's said, yes, he's in violation, I don't know what to do about it. Does this need to go back to Judge McBurney?
He was terminated from drug court. I asked them, so that means it's ours. He's not going back to drug court.
Well, but what about probation in general? I mean, and maybe Officer Brown can speak to this. I mean, is he still on probation in whatever case that was? You said there are many cases. Hey, Officer Brown.
He was still probation. Has here 1 day remaining on this case.
It's start over. You were choppy at the beginning.
I'm sorry, Your Honor. He still is on probation for this case, and he has 2 years and 1 day remaining for probation.
So was the consequences found by Judge McBurney simply to terminate him from drug court?
To terminate it from drug court.
Okay. Okay. Okay, anything further, Ms. Raz?
Your Honor, I did want to speak to Mr. Cox's criminal history. I did not mean to give the court the impression that there were many cases. Your Honor, it is my understanding that before the 2019 case that he's now on probation for. His most recent felony conviction was in 2012. Your Honor, there are 2 state court cases in which Ms. Butler is the complainant witness, one from 2019 and one from 2018. I'm not sure whether he's still on probation for those. I wouldn't expect that he would be, since they are misdemeanors. Let's see, it seems that he received a 12-month suspended sentence on 19 CR 002 006A. And then 18 CR 007 479A. I wouldn't expect that he is still under sentence for that either.
What was the 2012 matter?
The 2012 was the point that I was making was that is the most recent felony conviction prior to the 2019 felony case that he's on probation for. I understand that it involved strangers. It was an aggravated assault, and he did enter a plea, as he said, because he was ready to get it over with. He had already been sitting for several years. He expected the judge would grant him a time-served sentence, but that did not involve Ms. Butler, and it did not involve a domestic partner.
Okay. All right, if there's nothing else, we'll turn it over to Ms. McClure.
Thank you, Judge. Your Honor, in this case, the state would oppose bond, Your Honor, based on the fact that this defendant, he does have 4 felony convictions, Your Honor. The most recent one being this 2019 case, Your Honor, in which the same victim that is listed in this 20 SC case, he was the victim in that case as well, Your Honor. There also is a history of state court cases. There were 2 cases involving her, the same victim, Your Honor. Based on that alone, the state feels that there is a risk of intimidating witnesses, Your Honor, and also the state would argue that he is likely to reoffend if released, Your Honor. He, like I said, he has 4 felony convictions, Your Honor. He was also terminated from drug court for failure to comply. He was issued 2 sanctions for drug court last year, Your Honor. So, Your Honor, based on the fact that the state feels he is a risk of intimidating witnesses, the state feels that he is likely to reoffend, and the state also feels that he's a danger to the community, particularly this victim, Your Honor, based on the history alone. Your Honor, based on those facts, the state would oppose bond in this case, Your Honor.
Okay, let me go back. Ms. Raz, where do you say he would live if out on bond?
He would be placed with Georgia Works.
Oh, that's
so
right.
Georgia would provide.
Is that residential?
They do provide transitional housing, and then they will assist in Mr. Cox obtaining more permanent housing. And Your Honor, I would
go ahead.
I'm not attempting to hide the fact that Mr. Cox struggles with addiction issues and also anger management issues. And I would agree with Ms. McClure that if I was asking for Mr. Cox to be released on a signature bond or a straight bond, there would be risk. Yes, there would be risk of witness intimidation and risk of harm to the community. I think that is effectively dealt with if we're saying that Mr. Cox is only to be released to Georgia Works. By all accounts, drug court was helping him address the issues that he faces, and the pandemic, as it has for many people. Should I wait?
No, I'm sorry. I was just getting some paper.
Okay.
Yeah. Go ahead.
I was just saying that the pandemic, as it has for many people, has disrupted that continuity, that structure for him. And I believe that Georgia Works is something that can effectively give it back, can effectively help us make sure that he shows up for court, that he doesn't commit any additional felonies, that he gets the help that he needs. And I don't think that keeping him in jail is the best way to do that. I would I'll leave it there, Judge.
Well, let me just ask you, I mean, let me follow up on that, because tell me, you know, I'm familiar with Georgia Works, but I mean, are we saying he's going to live there? Is he going to be free to come and go? And
Yes,
what
ma'am.
exactly is the drug component of Georgia Works?
So, Your Honor, primarily it is a work program. However, treatment is also a part for individuals that need it. I did speak with the lead case manager at Georgia Works, Mr. Sims, who also indicated it's not there on the acceptance letter that Ms. Raz actually sent to you, but anger management would be a part of the treatment plan for Mr. Cox. And that was determined through the assessment that was provided by Georgia Works.
Will he
So
live? Will he live
He will
there?
live there, yes. Yes, ma'am, he will live there.
Will he be free to come and go?
Yes.
Okay. And how does he get there from jail?
We have actually been working with the investigators from Accountability Court. I did reach out to them today, but the person that actually handles the transport scheduling won't be back until tomorrow. So what typically happens is that we get a date that they would be able to go to the jail and pick him up, and they would actually transport him directly from the jail to Georgia Works. I just don't have that date at this moment.
So the accountability court that he just got thrown out of is going to take him to Georgia Works.
Yes, ma'am, they have. They have been, because the jail no longer does any transports, accountability courts has agreed to assist our office with transports.
Okay, so the only part about this that's concerning, or at least to the court, is that once he's there, if he decides he doesn't want to be there anymore, he can leave. I understand the bond may not say that, but nothing's going to prevent him from walking out the door.
And I understand the concern. That is actually the thing with any of our treatment programs. The only way to keep an individual in is through a locked door. That would be through jail or a psychiatric hospital. Unfortunately, our treatment programs, individuals, it's free will. So they have the will, we can't force them to stay. What we would just hope that Mr. Cox will do the right thing and stay as mandated by the court. But I do understand your concern, but there is no way to force him to stay there as with any treatment program.
And I've asked whoever the call in user down here to unmute. Is Ms. Butler on the line? I am not preventing whoever this is from unmuting. Okay. And Ms. McClure, are there jail calls or anything like that in this one?
Not to my knowledge, Your Honor.
Okay. Okay.
Your Honor, I would also like to add that the location of Georgia Works, it's about 20 steps from probation. So if he's actually required to report to probation, Georgia Works actually ensures that that happens. So Georgia Works is actually housed at the Gateway Center, which is in very close proximity to probation. So if that is a requirement, it would not be a challenge. They actually would ensure that he reports.
Okay, and Georgia Works is 8 hours a day, 12 hours a day, 24 hours a day?
The services are, well, they're there 24 hours a day. They have individualized times as far as treatment is concerned. There's relapse prevention, adult education classes. They also work as well. So an individual would come in, such as Mr. Cox, and would be required to actually have employment. So they have partnerships with different employers throughout the city of Atlanta. And so they would actually coordinate finding employment for Mr. Cox.
And Ms. Patterson, and actually anybody, do you have any kind of idea as to the, for lack of a better word, success rate of this I mean, again, I'm familiar with Georgia Works, but not in the post-COVID world.
Their success rate is 80%. And if you go to their website, it is georgiaworks.net, and you'll be able to get those statistics there as well.
Look at you. Okay. All right. Ms. Raz, anything else?
No, Your Honor. Thank you.
Okay. All right. Ms. McClure, anything else?
No, Your Honor, thank you.
Okay. I'm going to get something out just as soon as I can. I can't give you an answer right now. Thank you.
Your Honor, is this another case where we might expect an answer by the end of the
Might.
week?
Yep.
Thank you.
Thank you.
Thank
And
you,
I have
Judge.
to deal with both, right? I have to do the probation thing as well. Because
Yes, Your Honor.
probation pending. So if I were to grant a bond, what would we do about probation officer Brown? What would we do? Just keep him on it, keep him on the 2 years and 1 day, but isn't that based on drug court?
It is, Your Honor, but due to the fact that he is no longer in drug court, he was on track 3 for drug court, so he still has probation. He still has to do the remaining time of that probation, and we can continue him on probation, and if the court is willing, continue him on probation and make a special condition that he enter and complete the Georgia Works program.
And I'm sorry, I kind of closed this down and now I'm bringing it back up again. But Ms. Raz, have you talked to Ms. Butler? I mean, I know you said she testified.
Yes, Your Honor. I've talked to her several times. The most recent was yesterday.
And she wants
And I
him back.
believe Ms. White, she wants him back in the house. Yeah.
Okay. Okie dokie. And the children are
So their 2-year-old son lives with Ms. Butler.
Okay. And
Mr. Cox also. Sorry, Judge.
Go ahead.
So the 2-year-old son, Jakari, lives with Ms. Butler. And Mr. Cox also has a 15-year-old son named Kamari, who lives with Cox's mother right now.
Okay. And the cruelty to children alleged in this case is because when he punched or slapped Ms. Butler, the child was there?
I have no idea, Judge. I believe I filed a demur to that count in particular. I'm not sure what's judging.
Because there's no incident report.
There's no incident report and there's no child named in the indictment.
All right, I'll get something out by the end of the week. Thank you. Okay, who we got next?
Mr. Bates. Position 3. Sorry, that Bates. I mean, you know what I mean. He took down.
We've got number 3. Okay. All right. Are we ready, Samantha? I know it's going.
Yes.
Okay. Hang on 1 second. Okay. You ready, Samantha?
Yes, I am, Judge.
All right, this is the state of Georgia versus Toma Bates. This is 20 SC 176882. This matter is on, I think we began hearing this, and we can clarify that in just a moment. But today is January the 19th, 2021. Everyone appearing in this hearing is appearing via the Zoom teleconference platform. This proceeding is also being live streamed on the court's YouTube channel so that the public's business can remain open and accessible to it. And I'm going to turn this matter over. Is this you, Ms. McClure?
Yes, Your Honor.
All right, I'm going to turn this matter over to Ms. McClure to see if there are any questions you want to ask. And also, if you could tell me, remind me what it's on the calendar for. Go ahead, Ms. McClure.
I believe it's on for bond hearing, correct, Kat?
Sure. Yes, I'll be happy to speak to that a little bit. So, Your Honor, we were on the calendar on December the 15th of 2020. I argued bond for Mr. Bates at that time. Your Honor reserved ruling and asked that it be recalendared, one, at a time that we could have Mr. Bates available by video, but two, also so we could have Wanda Smith by video. Your Honor, at the time, that was who I represented to the court, Mr. Bates would be living with. I believe Ms. Smith may be on the call with us. I spoke with her earlier today. She's sick. I think she may have COVID. She described it as the flu with a loss of taste, which is very worrisome to me. Anyway, Your Honor, it is my understanding that Mr. Bates would not be able to live with Ms. Smith at this time, but I will go into more detail at the appropriate time.
All right. I'm sorry. Courtroom security just alerted. Okay. Ms. McClure, are there any questions? Let me let courtroom security out. Just 1 second. Okay,
Judge, you're on mute.
I'm muted.
Ms. McClure, would you like to ask any questions as to Mr. Bates' appearance here today?
Yes, Your Honor. Thank you.
Did we do that? Okay.
We haven't done that yet.
Okay.
Ms. Raz, have you had a chance to discuss this hearing with Mr. Bates?
I have, yes.
Would you mind if I ask him a few questions? Mr.
I
Bates,
would not mind.
Mr. Bates, can you hear me?
Ma'am.
Have you had a chance to discuss this hearing with your attorney?
Yes, ma'am.
And do you understand that you have the right to be physically present in the courtroom for this hearing?
Yes, ma'am.
And do you waive that right to be physically present and wish to proceed via Zoom?
No, ma'am.
Did you
So,
say?
Mr.
No, ma'am.
What Ms. McClure is asking is if you want to go forward with
Oh,
the bond
yes.
today by.
Oh, yes, ma'am. Oh, I thought you said don't want to be present. Yeah, yes, ma'am. I want to go with.
Yes, I just asked you if you waived your right to be physically present.
Okay.
The state is satisfied, Your Honor.
All right, Ms. Raz?
Thank you, Judge. I will try to keep it short since Your Honor has already heard my argument for Mr. Bates. Mr. Bates is 47 years old. I understand that he was born in Atlanta. He has lived here his whole life. Your Honor, he has 3 children, Martez, who is 21, Melita, who is 18, and Dominique, who is 7. Your Honor, I did see Miss Smith's phone number pop up, so I'm hoping she's with us. I saw it. I saw that she had entered, and then I saw that she left, so she may be having trouble.
Okay. Whoever is call-in user number 2, I have asked on a couple of occasions to unmute, so.
I don't think that's it, Your Honor. I saw it pop up as a phone number, and it was her phone number. And I don't see her right now, but I hope that she will join us in a moment. Your Honor, before he was working, before he was arrested, Mr. Bates was working at Restoration Mattress. Your Honor heard that he is on federal probation. Your Honor, he was placed at the Atlanta Recovery Center back in June 2019. And I understand that upon his placement at ARC, he worked at Restoration Mattress for about 8 months until he was laid off due to COVID. Your Honor, at that time, he didn't have I believe it's about $20 per day needed to stay at the Atlanta Recovery Center. He was, upon his release, when I spoke with Mr. Smith.
Wait, you want to repeat that just one time? You said he didn't have the $20 a day to stay at the Atlanta Recovery Center. And then what did you say after that?
He had hoped to live with Miss Smith upon his release from Fulton County Jail. There are 2 complications to that, Your Honor. And I'm getting a message from Miss now saying that she's been on since 1:05. They haven't called Mr. Bates' case yet. Could I take a moment to respond, Your Honor?
Sure. And I'm just going to do one thing.
Ready when you are, Judge.
Oh, okay. I'm sorry. I thought you were trying to get Ms. Smith. Keep going.
Thank you. So, Your Honor, the 2 complications, the first being that Ms. Smith is not available to house Mr. Bates, but also that Mr. Bates has a hold from the U.S. Marshals. I spoke with Travis Burer, who is Mr. Bates' probation officer, and Mr. Burer told me that he could expect that Mr. Bates could expect to be picked up by the U.S. Marshal's office and to face a probation revocation. I see Ms. Smith has just joined us.
Okay.
Your Honor, if Mr. Bates is found to be in violation of his federal probation, Mr. Burer told me that he is likely to face a 2 to 3 year revocation of his probation in that case. So, Your Honor, at this point, I'm asking for a signature bond to the jail. Through the jail to his federal hold. Your Honor, Ms. McClure has been very candid with me that nobody has been able to contact the complaining witness in this case since the incident. The incident, you'll recall, was as alleged by the complaining witness, was Mr. Bates pointed a gun at the witness. I believe that the evidence show that Mr. Bates got into an argument with this woman, that she had the gun, and that Mr. Bates took it away from her and left to de-escalate, to disengage from the situation in defense. But nevertheless, Your Honor, I don't think the state can prove the charges that it's brought against Mr. Bates in this case without a witness. I don't think that it serves any purpose to continue to hold him in Fulton County Jail. And I think we ought to let him go to his federal hold and deal with that.
Okay. All right, thank you. Ms. McClure?
Yes, Your Honor, thank you. I'll be brief as well because you have already heard bond arguments in this case, Your Honor. Based on Mr. Bates's criminal history, Your Honor, he does have 3 felony convictions. Granted, the latest conviction is from 2003, Your Honor. And the serious nature of these charges, Your Honor, the state would oppose a bond in this case. The state feels that there is a risk of reoffending based on the fact that he is on federal probation and now is accused to have committed this new offense, Your Honor. The state also feels that, and based on the fact that he does have 3 prior felony convictions, and Your Honor, the state would argue that he is a danger to the community, Your Honor. These are very serious allegations. So based on that alone, Your Honor, the state would oppose bond.
Well, is the state's concerned that if I grant bond and the federal marshal's office doesn't come get him?
Yes, Your Honor, that's the state's concern. Otherwise, if the state had some sort of way to ensure that when he is granted bond, that they were there to pick him up, then the state would be more comfortable. But Your Honor, based on that alone, that's why the state is hesitant to agree to release him to the hold.
So, Your Honor, the Fulton County Jail will not release him on bond as long as that hold is in place. That hold is in place. They're not going to release him from the Fulton County Jail until the U.S. Marshals come and pick him up.
Isn't the bond subject to the hold?
I'm sorry, Judge?
I'm sorry. Isn't the bond, no, stop that. Isn't the bond subject to the hold?
Well, he doesn't have a bond right now, Your Honor. If I'm asking that the bond be made through the jails, 1, so that he doesn't have to pay anything, and 2, so that we don't put him in a position where he's required to report to pretrial services while he's in federal custody. That would be impossible. But I believe the question is are they going to release? Are they going to take the hold off if we give him a bond? And the answer is no. I spoke with Mr. Burer about the state's position and our position. Mr. Burer made it very clear to me that he believes that the U.S. Marshals can prove a violation of probation. It can't prove its case, and that they fully intend to go forward with the probation hearing, revocation proceedings.
Kathy, haven't we done this before?
We can do a bond. The only thing is he's going to go to federal and then have to come back here and deal with a case that you're saying is not a case. So,
well, yeah, but I mean, haven't we done it conditioned on the hold?
Yes. So he can go to the hold, and then when he gets out of federal custody, he's going to have to come back here.
Okay.
Yes, Your Honor. So the way we would word it is, and at least this is how they used to do it in non-complex, that it would be a signature bond through the jail to U.S. Marshals hold only. And then the jail would presumably know that this SOB, the signature bond, is conditioned upon his release to the U.S. Marshals hold. Is that what you were asking? Yeah. I'm sorry. I think I misunderstood your question.
Yeah, I mean, I don't. How would that not satisfy the state's concern?
That satisfies, the wording of that satisfies the state's concern, Your Honor.
Okay, here's what I want to do, and I apologize again for being a little bit caught short on this. I want to work on the wording of this and get it circulated around. I'm presuming that I am in fact going to do something very much like this, but I just want to work on the wording first. Okay?
Thank you.
Okay, thank you, Mr. Bates. Okay, and we've got.
And Your Honor, can we expect that order to be circulated this week? Thank you, Judge.
Thank you. And we've got one more, which is Mr. Miller, I believe. Is everybody good with working on through this last one?
Yes, Your Honor. Jenny, I just sent you a message. I don't know if you got it. It's just about one aspect of the plea, Your Honor. So just
Is this a misdemeanor or felony plea?
felony.
With probation?
That depends on the response. I will know in 2 seconds. I'm sorry.
Okay.
Let me just go on mute. We will be a very quick phone call. Sorry.
No problem.
Y'all want to do that breakout thing? Jenny, come off mute. Oh, phone. I'm sorry. The phone. Sorry. I'll come off mute. Hey, Kathy, I realize you're tired and hungry. I'm hungry. But can we take some time this afternoon to just go over our notes?
Yes, ma'am.
Okay.
If you give me like 10 minutes so I can take my little one out after court, then we'll.
Courtroom security here is mad as heck.
Yes, I hear him, Judge.
Courtroom security is not only mad and kind of hungry, but also the tag jingling is a real hostile sign.
Yes, Judge, my security is beating down the door right now. My cats are not happy.
Yeah.
It doesn't get any stronger than this.
Yeah. Oh, goodness.
And I actually had to lock the door. My oldest cat, he's figured out how to open our doors. They're the lever doors.
Oh.
So he was trying to get in here, so I had to lock the door.
Oh, the only thing I have going for me is that my particular courtroom security does not have opposable thumbs. If you learned how to open a door, it would all be over.
Right.
You're back, Judge. I'm sorry.
I thought that's what you were referring to when you said courtroom security.
Courtroom security was fussy.
So is it a misdemeanor or a felony?
It's a felony without probation.
Without probation. Oh, yeah.
Nice. Mm-hmm.
All right, Samantha, you ready to sprint to the finish?
Yes.
Okay.
Yes.
All right. Good afternoon. This is the state of Georgia versus Eric DeAndre Miller. This is 20 SC 177039. Today is January 19th, 2021. Everyone today in this proceeding is appearing via the Zoom teleconference platform, including the defendant, Mr. Miller. I understand that this matter is on for a plea this afternoon. Mr. Miller is present. Again, we are all on the computer. I will also state for the record that this matter is being broadcast via the court's YouTube live stream channel, so that the public can continue to have access to its business. The state in this matter is represented by Ms. Lindsay McClure.
It's going to be me, Your Honor. I'm sorry.
Oh, look at me. So sorry. The state in this matter is being represented by Ms. Kelsey Jones-Connor, and Mr. Miller's being represented by Ms. Jennifer Lubinsky. And at this time, I'm going to turn this matter over to Ms. Jones-Connor to see if she has any questions regarding Mr. Miller's appearance today. And at that point, after that, she can take over. Ms. Jones-Connor.
Thank you so much, Your Honor. Mr. Miller, can you raise your right hand for me? Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
Now, did you have a chance to speak about today's proceedings with your attorney, Ms. Lubinsky?
Yes, I did.
Okay. And do you understand that normally you would have the right to be present in the courtroom and we would all be there, but because of the COVID-19 pandemic, we are proceeding via Zoom. Do you waive your right to be physically present for this hearing and agree to proceed via Zoom for the plea today?
Yes, I do.
Okay. And I just wanted to note for the court, Your Honor, that this is going to be a negotiated plea. The state does authorize the court to sign any documents regarding this plea on its behalf.
Thank you.
Similarly, the defense authorizes the court to sign documents on its behalf.
Okay, thank you.
And I'll just finish it out. Mr. Miller, at the end of this plea, if it is accepted, you will be asked, you would normally be asked to sign the indictment. Because we are appearing via Zoom, the court is going to sign that on your behalf. Do you authorize the court to sign that on your behalf?
I do.
All right, thank you so much. Now, if you would for me, please state your true, correct, and legal name.
My name is Eric DeAndre Miller.
Are you at this time taking or under the influence of any alcohol, drugs, or medication?
No, I'm not, but I am on psych meds.
Okay, can you tell me what that's for?
It's for schizoaffective disorder.
Okay, have you been given that medication today?
Yes, I have.
Okay, and does being on that medication, does it affect your ability to understand what we're going to be doing here today?
No, it doesn't.
Okay. Now, how old are you and how far have you gone in school?
I'm 40 years old and I completed, or I came into the 9th grade.
Okay, and you said
I entered the 9th grade or completed the 9th grade.
you completed the 9th grade and 40 years old, was that right?
Yeah, but I have my GED.
You do have your GED. Okay, thank you. And are you able to read, write, and understand the English language?
Yeah.
Okay. Do you understand that you are charged with the following offenses? For count 1 of the indictment of 20 SC 177039, the state is going to null pros count 1. And for count 2, you're charged with state sex offender registry violation. Do you understand?
Yeah.
Okay. And do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yeah.
Okay. Have you had enough time to speak with your attorney, Ms. Lebinsky, about all the facts and circumstances known to you regarding the charge that I listed in the indictment, including any potential defenses?
Yeah.
Okay. Do you need more time to discuss the case with Ms. Lebinsky?
No.
Are you satisfied with her services?
Yeah.
Ms. Lebinsky, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment as well?
So waived.
Now, Mr. Miller, just to confirm for the record, have you been arrested on the charge that I read out to you in the indictment?
Yes.
Okay. The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants that are related to the charges?
No, I have no other charges.
Okay.
No,
now,
Your
thank you. In 1 second. Of course, my computer froze. Always happens. Okay. Has your attorney advised you of the minimum and maximum sentence for each charge you are pleading to, that being for state sex offender registry violation? I believe it's your first offense of 1 to 10 years.
Yes, she has.
Okay. And do you understand that this is a negotiated plea of guilty, which means that the state will recommend a sentence to the court, but the court does not have to accept that recommendation. The court can sentence you to the maximum on that charge that I listed. And if there were multiple charges, run those consecutively or one after the other. Do you understand that?
Yeah.
Okay. The state's recommendation, or the joint recommendation on this case, Your Honor, is, again, count 1 is null prost. For count 2, it's 5 years to serve 1 year, commuted to time served. That balance to be suspended upon entry into the PAD as in dog program, which has 2 separate names. I know it's now under a new name. I believe Ms. Patterson will be able to explain that a little further for the record later on.
Okay.
Yes, ma'am.
Now, Mr. Miller, do you understand that this guilty plea conviction is permanently recorded on your criminal history?
Yes.
Okay. And do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
Okay. And do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Okay. And do you understand, I know in this case, we have asked for the probationary sentence to be suspended or the balance to be suspended. But if you were placed on probation, do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Okay. Now, are you a United States citizen?
Yes.
Okay. And do you also understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardons and Paroles, and no one can guarantee parole no matter what anyone has told you?
Yes.
I need you to speak up just a little bit.
Yes.
Okay, thank you. Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Okay. Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you understand that by pleading guilty today, you waive any and all defenses, including any mental health defenses?
Yes.
And do you understand that by pleading guilty, you are giving up these following rights: the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charge of state sex offender registry violation in indictment number 20 SC 177039?
Guilty.
And is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
And do you only understand, that you only have 4 years from today for a felony charge to file what's called a habeas corpus petition, which challenges the voluntariness of you entering this guilty plea?
Yes.
Your Honor, if this case were to go to trial, the state is confident in its ability to prove beyond a reasonable doubt that Mr. Miller was convicted of the crime of criminal sexual conduct in the 3rd degree in the state of Michigan on September 30th of 1998. That conviction did require him to register as a sex offender in whatever county in which he did reside. On December 26th of 2019, Sergeant Slocum, SLOCUM, with the Fulton County Sheriff's Office received a call from Officer J. Preem, that is JAIPREAM, of the Seal Beach Police Department in California. At that point, Officer J. Preem stated that the accused was just arrested in California for soliciting oral sex from 2 females at a local flower shop. The accused, Mr. Miller, did not have permission to travel outside of the state. In addition, he failed to report for his annual registration on his birthday of 2018. Because of those because of those incidents, Your Honor, the Fulton County Sheriff's Department did obtain warrants. The only felony conviction that we show for Mr. Miller is the Michigan conviction in 1998, which was the basis of his registry. We do not see any other offenses, from Mr. Miller. So taking that into account, we do ask that you accept this plea as negotiated.
What, Ms. Jones-Connor, was he living in Georgia? Had he been registered at all?
He had been registered up until 2018, Your Honor.
Okay.
So in 2018, he missed his annual. They didn't have a report for him. And in 2019 is when that offense signaled where he was. But
Okay.
up until then, he was compliant.
Thank you. All right, Ms. Lubinsky.
And Your Honor, his birthday was in December, and he was in California at the time of his birthday. So, Your Honor, he is 40 years of age. He is single. He has been diagnosed with schizoaffective disorder. He was not on medication for a long time. He's back on medication since he's been in the jail, and he is doing well on medication. Our concern was ensuring that there was a place for him to go to. And Your Honor, Ms. Patterson has been able to secure placement for him at the PAD program, which I understand has changed its name to Policing and Arrest Diversion Program. It will provide him with housing, and Ms. Patterson will be able to address the court on any questions the court may have concerning what other facilities the program does offer. Your Honor, Mr. Miller does not have a bad criminal history. He has literally been locked up since December the 26th of 2019, December the 26th of 2019. I would ask the court to accept the plea as negotiated. I would also ask the court to order that he be released with a 30-day supply of his medication, which is called Geodone, Geodone.
Okay, I do have some questions if this is a good time. Now, I understood the recommended sentence was that his probation would be suspended upon entry into the PAD program, but does that just mean he goes over, checks in, and then is on about his business? I mean, what is are we going to say his entry into and maintenance in that program, or what is the situation?
I know that probation some time ago did not like the wording that we used to use, which was entry into and completion of. So I know that that wording has not been used for some time. I think the wording, therefore, is purely entry into. And Your Honor, the point was to give him a place to stay and where he can get help for his issues.
Okay, but I just need a little bit more understanding that we're not just talking about, I mean, if you want to put him on probation, fine, let's put him on probation, but is it going to be satisfied by just going over, signing in, and then leaving?
No.
That's what I'm curious about.
No, Your Honor, that's not the intention.
Well, tell me what we're doing and we'll put it in to English words, and then everybody will know what is compliance and what is not compliance. Ms. Patterson, you want to tell us what this program is? I mean, I'm happy to say, you know, is entry into and, you know, attending if you want to put a time limit on it, but just entry into doesn't sound like we're answering anybody's issue.
Yes, ma'am. I'm actually getting, because Mr. Miller is actually the first person I have actually had connected to PAD, so I'm actually getting consultation here. I can go ahead and give you a little information while I receive a response here. So I will like the record to reflect the new name is actually Policing Alternative and Diversion Initiative. They were still PAD. Previously, it was pre-arrest diversion. And basically what they did was just kind of diverted arrest. But now they've opened their services to community referrals. And so that's how our office has actually been able to get connected. The way, what they would actually be doing for Mr. Miller is actually connecting him with the services that he needs. They would connect him with the mental health services, provide housing as well. We have had a few clients to be referred through PAD. Fortunately, actually, Mr. Miller is actually my first client. They would actually pick him up from the jail and provide temporary shelter or temporary housing for Mr. Miller. In that time period, they will work on, he has case management. They work to connect him with the mental health services. And in Mr. Miller's case, they would actually ensure that he registers. That was a part of some of the initial conversation that I had with the director, director of outreach, is that he would be required to register upon his release. I am trying to find out now exactly how the wording would be, so pardon me.
Well, I mean, can we put a time limit on it? Maybe that would be the best thing. I mean, can we say at least like 3 months or something of that nature? I mean, Officer Brown, do you know anything about these folks?
No, Your Honor, I don't.
And probation has been cited for the prohibition against saying completion of. I get that. I don't even want to say that, but I want to say something that prevents him from just going over there and going themselves. How about 3 months?
So I think, yeah, entry into and participation in the PAD program for 3 months, I think satisfies. We're really just trying to make sure he gets set up to do housing and have some support to get on his feet. And
it
so
doesn't feel like he's trying to game. He doesn't look like he's trying to game the system. I just want him to know what's coloring in the lines and what's coloring outside the lines.
Then or participation for at least 3 months. I don't want there to be a problem where they say after 3 months, bye.
Okay.
I agree with that.
That's fine.
So as long as it's at least,
I
imagine that should not be a problem.
That's fine.
And I think that Ms. Patterson was trying to work out when they would actually pick him up.
And
they won't release him without him being picked up. That is one.
I think I'm just getting a lot of noise at the moment.
Yeah, me too.
I think that might be Officer Brown's.
Yeah, put her in timeout.
Yeah. I think she just left. She's out.
Then I'll go.
Nice. Okay.
Well, what happened to Jackie?
She got kicked off right before that static started as well. So we might need to hold for her.
Okay.
Or I don't know. It's up to you, Jenny.
I think if we could hold on for Miss Patterson, because she should be able to give us the information on when Perhaps let me text her.
Okay. Can I go ahead and ask Mr. Miller some questions?
Of course, Your Honor.
Okay, Mr. Miller, I have some questions for you, sir. Did you understand the questions asked of you here today by the Assistant District Attorney?
Yes,
And you understand the rights you're giving up by entering your plea of guilty today?
yes,
And are you willing to give up those rights and go ahead and enter your plea?
yes,
Has anybody forced you to do that?
no,
Has anybody promised you anything in order to get you to do that?
no,
Are you satisfied with the services of your attorney, Ms. Lubinsky?
yes,
You think you've had enough time to talk to her about this case?
yes.
Okay. And I do on the 30-day supply, Jenny, I have not heard anything new about how long they will go out. I know 30 days is too long.
Can we try for 14?
Can we try for 6?
We always used to be able to get 7 without a murmur.
All right, I'll accept 7. Okay. I do find that Mr. Miller is entering his plea willingly, free. Oh, let me ask one other question. Ms. Jones-Connor, I heard 2 things on the possible sentence for this violation. At first, I heard you say 1 to 10. Then later on, I think you said 1 to 15. Which is it?
1 to 15 was if he's caught with a firearm.
Great.
1 to 10 for state sex offender.
That's a violation of.
Yes, if there was a possible violation.
Okay, that was my not understanding what I heard. Thank you. I do find that Mr. Miller is entering his plea willingly, freely, knowingly, and voluntarily. Do we expect Ms. Patterson to come back?
I'm not getting a response from her at the moment. I sent her a text, but I'm not getting a response.
I think as far as the plea goes, we have the information. He won't be released until he's picked up, but I guess she can be in touch with Jenny.
Yeah, I can draw up an order.
Okay. Well, then I accept.
Should the court be in a position to sign orders and e-file between now and kind of tomorrow?
Sure. I think I can do that. Yeah, I can do that. Now, I do accept his plea. I do find that his plea is being entered. I think I said this, but knowingly, willingly, freely, and voluntarily, I accept it. And I accept the recommendation, and therefore on 1 count, which is count 2, of violation of the state sex offender registry provision, the court hereby sentences you to 5 years to serve 1 year. That 1 year will be commuted to time served. With the balance on probation, that probation will be suspended upon your entry into the Policing Alternative and Diversion Initiative, and your remaining in that program for at least 3 months. There will be a provision in the, as part of the final disposition, that you will actually be picked up from the jail by this program, and the court will order that you have 7 days of your medication to take with you. Now, I think that's everything. Excuse me?
Jackie's back on, I think. And she sent me a text saying Friday at 9 a.m.
Okay. So they
Sorry about that. Everything just started spinning. So as I was stating, so Pat, he would get ongoing case management. So and I guess the way that it would actually read that is that he would be required for treatment, which is his mental health treatment would be through River Edge, and Pat is just that added resource. And so they would be providing him with basically a lifetime of case management. So as long as he wants those services, he's able to get them. I have the fortunate pleasure of being a part of the working group with Pat, where we meet on a monthly basis, and just seeing some of the transformations that have happened in a lot of their clients' lives. And they actually, I mean, they have clients who've actually been connected to them for years. So should he continue to want those services, they would actually provide a lifetime of connection with them. Again, they would be helping him with the housing piece, and making sure that he is connected to those mental health resources.
Okay, Ms. Patterson, we've already provided that he enter into, and I think I said it right, I hope, correct me, Policing Alternative and Diversion Initiative, and that he remain with that program for at least 3 months. Do you think we need to put River Edge in there? Do we need to, and receive treatment through River Edge Mental?
Yes. Yes, behavioral health treatment through River Edge. Yes, ma'am.
Yes.
Kathy, did you get that?
River's Edge. River's Edge.
Yes.
Okay, and then he gets 7 days medication from the sheriff's department.
He can actually, can we do 30? He would be eligible to receive 30.
I don't think the sheriff's department is issuing that much.
Actually, yes, we have actually been successful. They don't bark as much as they used to about the 30 days. It's only certain medications, but the mental health.
When is the last time you did 30 days through the sheriff's department, Ms. Patterson?
Absolutely, Judge. Hold on one moment. December 24th, 2020.
30 days.
Okay.
Yes, ma'am.
Thank you, Your Honor.
And so he's being picked up on Friday at 9 o'clock.
Yes, by a representative of PAD. I don't know who that is, so if it can just be worded, a representative of the Policing and Alternative Initiative program.
Okay, and Mr. Miller, did you understand everything that we were saying there, particularly about your participation in the program? The answer, yes.
Yes.
Okay, stay forever. Stay as long as you like. But all the court is saying is that I have to know, in order for you to be in compliance, that you are pursuing it for at least 3 months. But that is not in any way to suggest that you have to stop them. All right, I wish you the best of luck, sir. Is there anything else we need to do on that case?
Yes, Your Honor, I'm sorry. Can you just add that he be supervised by a mental health officer?
But it's not probation. He's not going to probation, right?
So it's
be in probation for 2 months, really. His probation is suspended after 3 months of participation at the program.
That's not what they said at first. Are y'all putting him in probation?
I thought it was the 5 to serve 1, balance on probation to be suspended upon.
No, balance suspended.
Suspended.
Okay.
Balance suspended. Then we won't have problems.
So if he doesn't do that, it gets picked up at some point, he didn't do it, then that can be a revocation.
That's correct. One can revoke his suspended sentence.
Yes.
But he doesn't have to report to probation or pay probation fees or anything of that nature.
Does that satisfy you, Officer Brown?
It does.
You got to understand he's important on this call. Okay, anything else? All right, it's been a long, good luck, Mr. Miller. We can stop that record. It's been a long day, everybody, and I